So we have an all-star lineup with us. They don't really need long introductions, so I won't spend much of our time. Paul Clement from Kirkland and Ellis, Jeff Fisher from Stanford Law School, Adam Liptak, of course, from the New York Times, and David Strauss from the University of Chicago Law School. And we're going to talk about the docket as it pertains to constitutional rights. So we're going to talk first about a Second Amendment case, and then what's going on in terms of abortion rights on the docket, and then finally a little more. The last panel covered some religion issues. We're going to talk about those as well. So I will just give it over to Paul to talk about New York Rifle and Pistol Association versus City of New York. There's a mootness issue and a merits issue, and he can introduce the case, and then he and Jeff Fisher, who's also involved in the case, can talk us through the issues. So, Paul?
Are you sure there's a mootness issue?
Well, there's an issue.
This is the court's first venture back into the Second Amendment for about a decade. Just to give you a short history of the Second Amendment, it was part of the Bill of Rights in roughly sort of 1789. It was kind of largely ignored until about 10 years ago, or 15 years ago, and the Supreme Court in a case called Heller sort of settled a question that many had thought had previously been settled the other way, which was whether or not the Second Amendment protects an individual right as opposed to just a collective right, or really almost like the rights of the states to form militias. In the Heller case, a 5-4 majority of the court decided that the Second Amendment does in fact protect an individual right. Just a couple of years later, in a case called McDonald, the court then held that the Second Amendment had been incorporated against state and local governments under the 14th Amendment. That was obviously a tremendously important decision because in the cosmic scheme of all regulation of firearms, much more of it is done at the state and local level than it's done at the federal level. So if the Second Amendment had not been incorporated in McDonald, it would have had a relatively limited reach. But having been incorporated, it then essentially applied at the state and local level. And so that really kind of set the stage and maybe an expectation that having sort of revived the Second Amendment and kind of revived the idea of it protecting an individual right, and then clarifying that it applies against every state and local government and applied to lots of laws that had been passed during a long period of time when the governing law in most circuits was that the Second Amendment really didn't have much traction. There was, an expectation, at least in some circles, that this would be a new part of the court's docket, and we'd talk about the First Amendment cases and then the Second Amendment cases, and they'd sort of develop the doctrine and how it applied in various contexts. And instead, what really happened is it seemed like the court was ready in the McDonald decision about a decade ago to incorporate the Second Amendment, and really wasn't ready to say anything else. And so the lower courts had developed a lot of doctrine, occasionally invalidating a state law or two or a local ordinance or two on Second Amendment grounds, but for the most part, I think the state and local governments did pretty well in the post-McDonald era in the lower courts, and a lot of doctrine developed in the lower courts that was fairly deferential to the interests of state and local governments, especially, fairly deferential in light of the Heller and McDonald decisions. And a lot of people, myself included, had spent some time trying to file cert petitions, trying to get the court to get back into this. And the court didn't seem to have that much interest until late last year, when the court did grant, as it was just kind of at the hinge point where it could decide cases either for last term or carry them over for the October sitting. The court granted cert in a case out of New York involving the New York licensing regime, particularly for premises licenses. And so in New York City, in a nutshell, there's two kinds of licenses you can get to possess a handgun. You can get a so-called carry license, which is, really difficult to get in New York. I think if you succeed in getting a carry license in New York, you should also play the lottery that day, because it is very difficult to get those. But then the more common form of license in New York is a so-called premises license, which allows you to possess a handgun in your home, but doesn't allow you to essentially to take it out of the home. And in particular, the challenge focused on the fact that you could not take the handgun out of the home to take it to a practice range in New Jersey. You could take it to one of 7 licensed ranges in the city of New York, but essentially nowhere else to train and practice with the firearm. And you also could not take it even to a second home. So if you were so fortunate to have a home in the city and a home in the suburbs, you couldn't have the same handgun in both places. You'd have to get a separate license and effectively a separate handgun for your second residence. So that was kind of where the focus of the challenge was, to this very restrictive regime on premises licenses. And I think it's fair to say, I think, there's much that Jeff and I could probably agree on here. There's much we could disagree with, but I think it's fair to say that the New York regime is pretty unique. This is not something that lots and lots of cities have had to resort to, or decided it was prudent to resort to. So this is, in that sense, a relatively unique provision, which I think probably, is helpful fact for the challengers that I represent on the merits, but maybe an unhelpful fact when it comes to mootness. We'll see. But so the case didn't end, in a sense, when the cert was granted. By kind of a fluke of timing. I think, if this case had been granted like 2 weeks earlier, and scheduled for argument last April, I don't know that there really would have been time for the city of New York and the state of New York to sort of do anything to try to make the case, quote unquote, go away. But because of a quirk of timing, and the case was granted in like January, I think, late January, but not going to be argued until October, there was a fair degree of runway for the city and state of New York to essentially try to think about whether they really wanted to defend the ordinance in the Supreme Court post-cert grant. And so there were actions taken both at the city and the state level to essentially change the laws in ways that make it possible to take the handgun to a range in New Jersey and possible to take it to a second home. So I think, and we can sort of see what Jeff has to say about this. But I think it's fair to say that what they were trying to do was very much make this case go away. And they followed those actions, well, actually even preceded those actions, but that's inside baseball. But they followed those actions by suggestion of mootness. And so what you really have in front of the court is 2 separate issues. You have the merits issue, which is still being briefed, and you have the question of whether the post-cert actions of the city and the state essentially make the case moot. I'll talk just one more minute about the merits issues, then let Jeff focus on the mootness issues. All I'll say, at least initially, about the mootness issues is I think both these issues are interesting. So, I think if the court were to decide the mootness issue definitively, at least in a written opinion, as opposed to just taking some motions action, that would be an interesting mootness opinion. And if it decides the merits, it will be very interesting, if for no other reason than it will be, essentially the third meaningful Second Amendment case in the nation's history, or at least in recent history. I think with respect to the case, this is a case that the court could decide very narrowly and really focus on the New York premises licenses regime, the specific restrictions, either in the pre-existing law or that continue, and really say almost nothing besides, that this particular ordinance is valid or invalid. I think if it says that it's valid, I think that would be a pretty persuasive holding for all sorts of implications for all sorts of other things. If the court said it was invalid, I think they could either rule quite narrowly, or they could essentially provide some indications that, the Second Amendment may be more protective than some of the lower court cases have suggested, and issuing this decision sort of essentially kind of restart the process that may have started in McDonald of kind of letting the lower courts wrestle with some of these issues about how you actually apply the Second Amendment in practice to particular regulations. There are certainly ways that the court could decide the issue that have implication for the right to carry, which is an issue that's been litigated probably in more cases, including a couple that would be waiting in the wings for the court if it decided that this case was moot and it wasn't going to decide anything in this case. So I think, happy to talk more at some point, but I think that's just a basic lay of the land. On the merits, I think there are different off-ramps for the court to decide the case, relatively narrow or relatively broad.
jump in? Sure. Well, again, thanks for the opportunity to be part of the panel. I'll say a couple words about as Paul says, the two different issues, the Second Amendment issue, the mootness question, and then circle back to kind of where Paul began, is maybe a higher level view of this area of law and where the court is at. So as to the Second Amendment issue in the case, I'll just, I think, echo in many ways what Paul said, which is the court could look at this case in a couple of different ways. One is a very, very narrow question of whether the Heller right to own a gun inside the home sort of includes as an incidental adjunct to that right the right to transport it from one home to the other or to a firing range to practice. And so it keeps it very much as sort of the Heller home right. And that fits, those sorts of arguments fit within a premises licensing regime. As the case has been briefed at this stage, there's also a layer of briefing, I think it's fair to say, in Paul's briefing and the others, and in general on the amicus briefs on the other side, that is also a much broader conception of how the court should think about this case as the Second Amendment truly outside the home, as a distinct component of the Second Amendment, the right to bear arms in public and to carry them in public. And that would be far, far more significant if the court thought of the case that way. I mean, for my money, this would be a very odd case to do that in, not just because of the mootness thing, which I'll talk about in a minute, but because, as Paul said, that New York City has two different licenses, a carry license and a premises license. And so if the problem is the city is being too strict when it comes to the right to carry in public, you'd think the challenge would go to the carry regime, as it is going to in a New Jersey case that the court is holding right now. So it'll just be interesting to see how the court approaches all of that. And I'll say the one other interesting thing, and maybe Tim, you'll want to say a word about this, is that there's some interesting conversation, kind of a battle of analogies in the briefs as to whether the Second Amendment should be thought of as a right like everything else, or as, to put it the other way around, a second-class right. And so I think Paul, gives a powerful analogy in one of his filings, I think to the effect of, well, what if the city of New York said you can only visit libraries inside the city and not libraries outside the city? That would be outrageous under the First Amendment. And so if you move that down to the Second Amendment, that should just decide this case. On the other hand, the city's position is that well, as a matter of Second Amendment law, there should be some compelling interest versus narrow tailoring and some means end scrutiny that would enter the picture somewhere here, and that's being fought against to the other side. And so we're saying, well, geez, that would make the Second Amendment like a super duper constitutional right and not like the rest of the rights if the city didn't have the opportunity to come in and explain itself as to the public safety rationale and the like. So if to the extent the case gets litigated and argued and decided on the merits, it'll be interesting to see how the court views that debate. As to the mootness story, it's in some ways very, very simple, so I'll just lay it out, and I'm happy to let Paul or the others jump in. As Paul said, after the court granted cert, the city commenced a notice and comment proceeding. The actual law at issue in the complaint targets and in the lawsuit is a city regulation that is a notice and comment regulation of the city of New York. And so new proceedings were set underway at the city level. Meanwhile, in Albany, the state legislature took a fresh look at the state's gun regulation regime. And in July of just a couple months ago, both of those processes ran to their completion with the I think in the order the state of New York first enacted a law that the governor signed, giving any individual with a premises license the right to transport that gun to any other place in the state where he or she has legal right to have it. And so that obviously it covers not just shooting ranges and second homes, but other places where the person would have a legal right to have it, and saying any local law to the contrary is preempted. The city itself also changed its law to conform now to state law, and provides, I think as Paul said, that people can now take their guns to their second homes or to firing ranges outside of New York City with the premises license. And so in our view, this is not very hard. When you challenge a law saying this law violates my rights, I want to do these two things, and then the defendant government changes the law and says, okay, you can do them, that's pretty much the end of the case, at least traditionally, as we've understood Article 3. I think there's really two issues if you dig a little deeper under the surface, and the first is, are we in fact, has the city and has the state law in fact given the plaintiffs everything that they've asked for? One set of arguments in Paul's papers, it's kind of funny that we're describing each other's arguments, but feel free to weigh in. I'm just trying to put the issues on the table. Is that, what they've asked for is a judicial decree that they have a constitutional right to do these things, and anything short of that leaves it at sort of the privilege of the legislature or a local regulatory body is not the full relief they're asking for. To my mind, if that were correct, I don't know how any case could ever be moot. The other argument is that in various ways, these regulations in the New York state law does not, in fact, give the plaintiffs everything they want because of various other, they may not have a right to stop and get coffee if they're transporting their gun from one place to the other. They may not be able to take it to their beach home, even though they can take it to their summer home if the beach home is just a rental, and et cetera. And our response to those things is, well, when we're just now changing the case, and many of those things are covered anyways. And then the second big issue under mootness is voluntary cessation. The court has a doctrine developed with respect to private parties that says that if a defendant just ceases the activity that's claimed to be unlawful, that itself doesn't moot the case unless the defendant shows with a very, very high showing that they cannot be reasonably expected to resume that allegedly unlawful activity if the case goes away. The court has, notwithstanding that doctrine being out there, the court has always treated governmental changes of law different. Not necessarily governmental changes of practice or policy, but when the government has actually changed a law, with one exception, the court has always treated that differently and not subject to voluntary cessation. The one exception is a case, I believe out of Florida, where the municipality actually told the justice at oral argument, if you dismiss this case, we will in fact change our law back to what it was. So that would have made that argument pretty difficult.
Yeah, they should have worked on that answer.
Exactly, they didn't workshop that one enough. That's why Irv has his program now. To help people with situations like that. But we think obviously that's not the case here. We've explained that we being the city, have no intention to go back to the old regime, and in fact we couldn't because state law would prevent us from doing it anyways. And so in a sense we would say the case is kind of doubly moot. One last thing on the procedure, I'm not sure if we laid that out, but the court actually, I think yesterday, scheduled the case for argument the Monday after Thanksgiving, that wonderful date you always hope you're going to get when the court grants cert. So the case is scheduled then. Meanwhile, it does have our suggestion for mootness scheduled for the end of summer conference. So it's theoretically possible that the court could issue some sort of order, whether taking it off the docket, directing the parties to give more briefing, do something different, who knows. But I think, it may well be the case just goes ahead to oral argument, and all this is folded into oral argument, and the court kind of goes from there. One last thing I'll just say that maybe this is a little more for the students in the room that I just find really interesting, and back to Paul's overview, which was really helpful about the Second Amendment litigation as it's kind of gone forward, is that just as if you think about it even broader as a form of if you think about the civil rights litigation more generally, ever since McDonald, the gun rights advocates have been arguing, please court, take the Second Amendment outside the home, give us a right to carry, give us some sort of government of right to carry guns in public. All of these cases sort of making that big ask have gone up to the court and not gotten through the door. And so I think it was, made a lot of sense for them to take a different tack and say, okay, let's ask for something very small and incremental. Let's just inch it outside the home for this little bit of transport and from one place to the other. But that also opens up sort of counterplay that the city and the state have now said, which is, on reflection, if that's what you want, you can have it. And so, the question is whether they have to take yes for an answer.
Well, I participated in this case in a really, really minor way, so with an amicus brief that addressed the specific argument that the Second Amendment has been treated as a second-class right. which really goes to the standard of review. I mean, what standard of review should apply to regulations of gun rights? And part of what Paul's brief says is, look, the Second Amendment is a fundamental right. And when a fundamental right is implicated, then strict scrutiny applies. We can win under, any version of heightened scrutiny you can imagine, but strict scrutiny should be the standard. And that's, to my mind, that's not true of the Free Exercise Clause. It's not true of the Free Speech Clause. It's not true of abortion. It's not true of voting. So I wonder, how much of that is just a rhetorical claim, which what you really want is some form of heightened scrutiny. And I wonder if you could speak to sort of, I know there are a lot of different ways the court could decide the case, but it seems as if the main point of contention, or one of the main points, is how are our Second Amendment regulations going to be reviewed by courts going forward?
Yeah, and, without getting to the specifics, I mean, I think you could look to lots of rights that, are given more protection in the tests that are administered to them than the Second Amendment is given in a lot of circuits right now. But, rather than sort of quibble with that, just to kind of broaden the lens a little bit, what I would say is, one of the more interesting things, I think, about the Heller case, and, this is an issue that I gave a lot of thought to because at the time Heller was being litigated, I was, in the SG's office. And so, the question of how the court was going to analyze not just the D.C. statute, but a whole bunch of federal firearm regulations that the Solicitor General's office was duty-bound to defend as constitutional, that made a huge kind of difference to us institutionally. And so that was an issue we gave tremendous thought to. And then the court in kind of Heller, in a way that, it's great to be a justice. They can just sort of, no, I know all you litigants are talking about this standard or that standard, but just boom, here's our decision, and our decision is essentially not to decide a standard of review and to just basically say, look, statute in front of us is a complete ban of the thing that we think is most useful for an individual to exercise what we think is the core of the right. So this fails any level of scrutiny, and we're done. And, McDonald, the only real question in McDonald was the incorporation question, so they didn't advance that ball at all. To me, the really interesting aspect of it was, and I think it was, the chief had a question at oral argument that was kind of built in the idea that, look, in the First Amendment context, we had a lot of baggage with all of this, heightened scrutiny, intermediate scrutiny minus for certain election regulations. Why, when we're kind of breaking new ground, why do we want to sort of, take all the baggage from the First Amendment? And I don't think he quite said it, but I think implicit in it was the idea that maybe he didn't think the court had necessarily covered itself in glory in the way that it had analyzed all the different First Amendment issues and kind of layered sort of doctrine on top of doctrine in ways that, I think in fairness, in a decent number of First Amendment cases, the entire argument is really about which box you stick the law into, because that's going to dictate the outcome. And there's actually less discussion among the parties as to whether the law is kind of, vel non, kind of more consistent with the thrust of the First Amendment or not. And so it's just a long way of saying, I think it's kind of where the chief seemed to be. I think it's maybe a fair inference that the chief is going to be a very important vote in this case. And so, I wouldn't be that surprised if the court in the end here, says something about how to analyze these cases, but doesn't necessarily sort of satisfy the urge to say, oh, it's strict, or it's intermediate, or it's, the fill-in-the-blank test, but just continues this kind of almost like common law process of trying to deal with these cases. I don't know, but it'll be interesting to see.
Could I ask one Second Amendment question? So what do you guys make of this very odd brief from Senator Whitehouse?
Is that a Second Amendment question?
It's a Second Amendment question. It makes the point it makes the argument that the Supreme Court is illegitimately partisan and irretrievably broken, and if you were to rule in favor of Paul Clement, that would be the end of everything. And then every single Republican senator writes a letter and said they're really talking about court packing, and don't worry, guys, we're with you. who does this, how does this play into the case? Does it matter to the decision-making process at all?
We'll see.
Yeah.
That's the too soon to tell answer.
Yeah.
Yeah, I think one of the lunch panels talked about that exchange of letters from the senator, or I guess one was a brief and one was a letter to the clerk that's not been filed on the docket. But one hopes they're just set aside.
Adam, why don't you talk about the abortion docket?
We've talked about the abortion case the court is very likely to take. It's on for the October 1st conference, June Medical Services. And it's a case that matters on several levels. It matters as to admitting privileges laws. It matters as to whether the court is going to adjust the standard for analyzing abortion restriction laws, the Casey standard about what's an undue burden, what's a substantial obstacle. It's going to tell us something about whether a change in personnel at the court will seem to change the result in a case. And we've seen this before in the abortion context, where two very similar partial birth abortion laws got different treatments when Justice Alito replaced Justice O'Connor. And it will tell us something about how the court views its own role vis-a-vis the circuits, where even if it might be inclined to go in a different direction, it might not want the circuit to anticipate where it's going before it does. So anyway, the case involves a Louisiana admitting privileges law. Admitting privileges laws are a very, you can call them, clever way to restrict abortion rights, because it sounds like a great idea. Like, why not? Why not have your doctor also have admitting privileges at a nearby hospital? And it turns out that admitting privileges are, for a variety of reasons, both unnecessary and hard to get. Abortion is a very safe procedure, and hospitals usually grant admitting privileges to people who do a volume business. And because you have no particular reason to go to the hospital, you might not be even on economic grounds being granted admitting privileges. And then there are parts of the country where they don't want to give admitting privileges to abortion providers. So the practical consequences of these admitting privileges laws is to drive down the number of clinics and the number of providers who can provide abortions. In 2016, the court looked at the Texas version of this law, which most people thought would have driven the number of abortion clinics in the state from about 40 to about 10. And 5-3, Justice Breyer, writing for the majority, analyzed this in a cost-benefit kind of way. The asserted interest in favor of these laws is advancing women's health. And Justice Breyer concluded that not a single woman would be better off as a consequence of having such a law. But it would impose very significant burdens, notably long travel times, in getting to abortion clinics. And in this very mild-mannered, technocratic, cost-benefit way, comes to the conclusion that the Texas admitting privileges law has to be shut down. You wonder whether Breyer was the right person to be assigned the decision by Justice Kennedy, that Justice Ginsburg would have been eager to have the assignment and would have written it more broadly and maybe with more teeth. But what you get out of the Breyer opinion is a sense, maybe, that this is not a legal proposition. It's an analysis you can do even with an identical law on a different set of facts. And Louisiana has the identical law, and is enjoined by the district court based on the 2016 decision. But the Fifth Circuit reanalyzes the facts. It says, yes, we understand those legal propositions, but we're going to look at it, and we've now identified a state interest that wasn't present in Texas. There's, lo and behold, a credentialing function of having admitting privileges. It tells you something about the quality of the doctor that wasn't present in the Texas case, so that's a state interest. And you have the sense also that this is really like rational basis review. We're not going to second guess the legislature. If they think it matters, we think it matters. And then there's also this kind of slicing and dicing of a concept I've never fully understood, whether it affects a large fraction of women and what's the numerator, what's the denominator. But anyway, the Fifth Circuit manages to figure out that the identical law is different in Louisiana, even though in Louisiana, and this is contested, but it may well be that it would drive the number of abortion clinics to 1 and drive the number of abortion providers to 1. So it would have a very drastic effect. This comes up to the U.S. Supreme Court on stay application, and hours before the law is to go into effect, at 9:30 at night, a 5-justice majority, the Chief Justice plus the liberals, stays the Fifth Circuit decision pending the filing of a cert petition. And it's hard to know what to read into that. There's no reasoning. It may be that the Chief Justice, obviously the controlling vote, who was in dissent in Hellerstedt, thought that whatever was going to be done here ought to be done by the Supreme Court. Hard to tell, but it does suggest very strongly that the court will take the case. Now, Jeff's involved in the case, and he can say a little bit more. His side makes the pitch that this is so easy they should summarily reverse, and I can see the logic of that. But I don't think that's the most likely path forward. I think they probably set it down for merits argument, and I think they're going to scratch their heads, and the right side of the court is going to find ways, without overruling Hellerstedt, to apply what they're going to say is the standard from that case to these facts to reach a different result.
Do you want to say something?
I'll say two quick things, invite the other panelists to weigh in as well. We're just picking up where Adam left off. It was a great description. I got involved in the case. I am involved now with the plaintiffs, but I got involved very late in the cert process, just for the last filing. But as I've looked at it and thought about it, the analogy, you talked about the partial birth abortion duo of cases, but the analogy that came most quickly to mind for me was Citizens United in the sequel from Montana. And in many ways, if you read the Fifth Circuit's opinion, it reads just like the Montana Supreme Court decision in that case, which says, we have a decision from the Supreme Court announcing a constitutional rule that depends on a bunch of facts on the ground. In the Montana case being, whether certain campaign contributions pose a problem for corruption. And the Montana Supreme Court says, well, we have a different regulatory environment in our state and a different set of facts on the ground, and so we're going to come to a different conclusion than the Supreme Court came to in Citizens United. Not because we disagree with the legal principles the Supreme Court announced, just because the facts in Montana are different. And that's basically exactly what the Fifth Circuit did in this case, which is say the facts on the ground in Louisiana and the regulatory environment in Louisiana are different than Texas. And so, it would be very interesting to watch whether this gets the same treatment that the Montana Supreme Court decision got after Citizens United, which, remember, I think was a one paragraph, maybe two, but I think it was one paragraph from the 5-justice majority in Citizens United saying, we've already decided this case, and Montana obviously has to follow the same rules everybody else does, and not even engaging with the factual
And that was a summary reversal.
That was a summary reversal. So that's that's kind of the analogy, at least the hopeful analogy, where I'm sitting in the case and thinking about it. The other thing I'll just say that's kind of just interesting is that the state of Louisiana, and we started the day talking about the other case I'm involved in against Louisiana, Ramos versus Louisiana. Here we have Louisiana again, and at the back of Louisiana's brief in opposition, they say, if you don't accept the Fifth Circuit's distinctions, you should overrule Holmes Health. So Louisiana has put that squarely on the table for the court and made that request, which will become all the more prominent if the court were to grant cert and hear it on the merits. And remember this morning I said the state of Louisiana had made this curious decision in Ramos actually not to argue stare decisis very hard. And I've always wondered, and this is just pure speculation on my part, but whether the Attorney General's office is sort of realizing, well, if we have to be against precedent in one case and forward in the other, that's going to create a problem, so we'll just we'll make a different set of arguments in the Ramos case and argue for Holmes Health to be overruled if the court takes certain Louisiana case.
Well, Adam, I know you've been paying particular attention to this part of the docket. I mean, there was the Indiana case about fetal remains and Hellerstedt. Do you have any sense, and I'll open this up to the panel, how close this court might be to addressing a more frontal assault on Roe and Casey?
So it's hard to speak of the court as a unit. I think the Chief and maybe Kavanaugh are perfectly open to abortion restrictions that require the application and maybe the reformulation of the Casey standard. I think we're going to see those cases. I think there are 3 members of the court who would cheerfully put a frontal assault on Roe on the docket, and the CERT conference discussions about how fast to move and when will be intense, and I don't think John Roberts is eager. I don't think he's eager in the least to be put to the test, because if put to the test, he's going to vote to strike down Roe. But he doesn't want to be put to the test. So much of this turns on Kavanaugh. But I just don't think John Roberts wants the banner headline, Supreme Court overrules Roe v. Wade. The Supreme Court has enough legitimacy problems without that, and it can do plenty of damage to abortion rights without doing that.
I'll just say, I think the only interesting question is whether they'll be left that option.
Right.
Because
Right.
states
No,
and lower courts, this is
Well,
part of the conversation we had
case, an
earlier,
example,
can
right.
force things up to the court. Even a frontal assault from the state could be forced up to the court.
Yep.
Other thoughts on that topic? If not, we'll move to the religion case, the Free Exercise and Establishment Clause case out of
Montana, yes, case of Espinoza against Montana Department of Revenue. Adam is arguing the case in the court. He has it now. So let me give you the background from which this case and issues like the one presented in this case arise. Governments support private institutions that do worthy things in lots of ways. There are private institutions out there providing various kinds of services. There's schools, social service organizations, and so on. And governments support them either directly or indirectly by providing services to them, by providing money to them, or indirectly by using the tax code or tax subsidies to encourage people to give money to these private institutions. These private institutions are both secular and religious, and there are some limits on government's ability to support religious institutions, especially when they do it directly by direct grants of money. This case isn't that. This case is one in which there is no question the government could provide the kind of support to a religious institution that is at issue in this case. But the question here is, what if the government, in a situation which it could provide support to a religious institution, decides not to, while still providing comparable support to secular institutions? So specifically, Montana has a program in which you get a tax break if you give money to a private organization that provides scholarships for kids to go to schools. And apparently there's only one such foundation-type outfit in Montana. It provides scholarships for both religious and secular schools, and you can get your tax credit, I think it is, if you give money to this foundation. Montana decided through a variety of steps that based on Montana law, it could not continue to provide funding to this, funding is the wrong word, this sort of support, indirect kind of subsidy to the religious institution. The way it played out was, at first, the Montana Administrative Agency issued a reg saying you can't provide this tax subsidy cannot be available to this foundation because it is funding scholarships for religious schools. That was litigated, and at the end of the litigation, the Montana Supreme Court said, well, actually, we have to strike down this entire tax subsidy program. So the state cannot provide money for this foundation, whether it's providing scholarships for religious schools or secular schools. Nobody gets this money. Religious schools and secular schools will be treated the same way, and nobody will get this kind of support from the state. Now, this question of the extent to which a state can say, well, we know we could provide indirect forms of support to religious institutions, but we choose not to. To what extent can a state say that without stepping over the line and engaging in unconstitutional discrimination against religion, because after all, it's treating a religious institution less favorably than a secular institution? That's a difficult question. It's precipitated a lot of litigation in the lower courts. There are a couple of key Supreme Court cases on the question. One is a case called Locke against Davey, in which a state, I think it was the state of Washington, had a program that indirectly subsidized tuition payments to institutions of higher education, but it decided not to provide subsidies to people who are studying for the ministry, devotional theology. Although you could use your scholarship to engage in other kinds of religious education or religiously affiliated education. You could study theology, you could study a religiously affiliated school. You couldn't study to become a clergyman. And the court said that's okay. The Washington could subsidize that if it wanted to, but it's up to Washington. It has the option, excuse me, to decide whether to subsidize that or not. Then there's been a lot of litigation in the lower courts about just how broad is this devotional theology category. just how far does it go? How far can a state go in saying, well, that is really too religious, we don't want to subsidize it, before it crosses the line and starts discriminating against religion in an impermissible way? That's one key case. And there's been sort of a lot of talk in the lower courts about how problematic this is, and the petition in the Montana case latched onto that and said, look at how confused the lower courts are on this issue. A couple of years ago, the court had another case called Trinity Lutheran. The issue in that case was whether a program that provided for, it actually was an environmental program, it recycled scrap tires to allow for playgrounds to be paved in schools. And the state, I think it was Missouri, said it would not provide this benefit to a religious school for its playgrounds. The court said that was unconstitutional. That fell on the other side of the line. That was discrimination against a religious institution. But there was a footnote in the opinion in which the chief, a rather peculiar footnote, in which the Chief Justice who wrote the opinion said this is only, basically said, I'm caricaturing a little, but only a little, this is only about scrap rubber recycled to repave playgrounds. This is all it's about, nothing more than that. And that footnote precipitated a dissent or a concurrence from Justices Thomas and Gorsuch saying that's ridiculous, we don't agree with that, this goes much broader, and this sort of discrimination, as they characterize it, against religious institutions is unacceptable in a much wider variety of contexts. So that's the background to the case. It's a very difficult, conceptually very difficult issue, I think, because there are, everyone agrees, I think, there are limits to what the government can do as far as supporting religious institutions. It's implicit in the, it's really almost explicit in the Establishment Clause that even if religious institutions are doing worthy things, as they often are, that doesn't give them the same claim on government resources that secular institutions get. After all, the government operates a system of secular public education and can't operate, let's assume, a system of sectarian education open to all. On the other hand, at some point, it begins to look like discrimination if the government carves out religious institutions from a generally available benefit program. And it's actually, I think, a genuinely difficult line to draw. You can easily think of horrible hypotheticals on both sides of that line. What makes this case really peculiar, and a peculiar case for the court to take, and you wonder whether the enthusiasm of some members of the courts to sort of jump in and resolve this issue in favor of the religious institution got the better of them. What Montana did here was to say, well, we're not going to give this benefit to anyone. So you don't have an instance actually, at least on the face of it, of discrimination. No one is getting this benefit. It's not as if, as in Trinity Lutheran, secular schools are getting it and sectarian schools are cut out of it. No one's getting it. Now, of course, there are contexts in which if you deny a benefit program because you don't want some subgroup to get it, that would constitute discrimination. The sort of the case that comes to mind, Linda Greenhouse mentioned in the column she wrote in the Times about this a while ago, a couple of days ago actually, is a case in which in the desegregation era, a locality closed its public swimming pools and it closed them to avoid desegregating. The Supreme Court actually said that was okay, but the case has been pretty well discredited, and it's pretty clear you couldn't sort of close your parks because you don't want to open them up to racial minorities. But of course, religion is different from that just because it is quite clear that the government doesn't have to provide the same sort of support to religious institutions as it does to non-religious institutions in every instance. The sort of hypothetical that I think of is supposing religious institutions said, you know, we have a great way of keeping people who've been convicted of crimes from going back and committing more crimes, which is we proselytize them and we convert them. And we will put our success rate in preventing crimes up against any secular institution out there. Supposing the government is funding some crime prevention programs, does it really have to subsidize proselytization? If the proselytizers can show when we convert people they commit fewer crimes, that can't possibly be consistent with the Establishment Clause. So there are difficult lines here. As I said, what is striking is that the court jumped in here without realizing this case had the additional complexity that there's actually no facial discrimination. And I think the question is whether, I don't see any likelihood, having taken this case, that they will rule in favor of Montana. I mean, Adam is a genius, and maybe he'll persuade him to do that, but I think it's going to be a tough haul. But maybe they will see this is really not the case in which to decide this question because of this quirk, that what it ended up with is not actually discrimination, but a across-the-board decision to end this benefit program.
Thanks, David. Well, I mean, one of the interesting things about the Montana case is it does involve one of the so-called Blaine Amendments. And I wonder if you could speak to how that might complicate, how the court sees this case. There are 38 states have these provisions. It wasn't at issue in Trinity Lutheran versus Comer, but it is here.
Yeah, the Blaine Amendment was a proposed federal constitutional amendment back in the 1880s when what was the slogan that people ran against Catholic candidate Romanism and rebellion? The Democratic candidate ran against someone in the 1880s, Benjamin Harrison. I guess it must have been in the 1880s. So anti-prohibition, Catholic, and siding with the Confederacy. So it was a period of a lot of anti-Catholic sentiment. This is a proposed federal constitutional amendment. It did not pass, but a lot of states passed little Blaine amendments. The amendment forbade states from aiding religious schools, but it was generally understood that the religious schools in question were Catholic schools. I gather, though, and this is from a sidebar conversation I had with Adam, that while Montana has a little Blaine amendment, it recently revised its entire constitution and reconsidered that amendment, and the amendment was modified in various ways, and there were various explanations given for why there's still a constitutional prohibition against giving aid to religion, including explanations given by religious people who said we would rather not have government sticking its nose into religious business. Notwithstanding that, one of the arguments in the petitioner's brief in Espinoza is that this is all about the Blaine Amendment, and the Blaine Amendment is discriminatory against Catholics. And even though the end result is that secular and sectarian institutions are treated the same way, even though that's true, that's all a result of the Blaine Amendment, and therefore contaminated by the anti-Catholic animus that the Blaine Amendment, little Blaine Amendment, reflects.
Is there any kind of federalism overlay here? I mean, shouldn't states be able to make their wall between church and state a little higher, a little lower?
I think incorporation means no, right?
Well, I mean, that may end up being the answer, but, there used to be language in religion clause cases that talked about the play in the joints between the Establishment Clause and the Free Exercise Clause, and, and Locke v. Davie is,
That's right.
Perhaps going to be the only example of that, but, that is an example of that, which is, there's some areas where, the Free Exercise Clause doesn't mean you have to fund the ministry education, but even where the Establishment Clause would allow you to do it. I think what makes it tough, though, and I think what's going to make Adam's job difficult here is, the court went through, a very deliberative process to decide that for purposes of the federal Constitution, there wasn't an Establishment Clause problem with this kind of funding, indirect funding of religious schools. And a big part of its analysis to get to that result was that there was a fair amount of attenuation between the state funding and the religious entities, and there were intervening individual choices that kind of, were, I think circuit breaker was a word that was used in one of the opinions. And I think what makes this a tough case for Montana is, at least as I understand the way this program is set up as like a tuition credit, it's pretty darn attenuated. It's even more attenuated than sort of a maybe classic voucher program. And so if you're trying to weigh the sort of interests of the state in trying to avoid this fairly attenuated association with religion on the one hand, and then you're trying to weigh that against a parent who has decided that it's in the best interest of their child to go to school X and not school Y, and the state provides a neutral program to allow them to do that, I think that's a tough dynamic for the state, because it does seem like the individual interest is pretty direct and the state's interest is pretty attenuated. And I think that's a little different from the Locke v. Davie dynamic. So it's a long way of saying I think there's some federalism, some play in the joints, but I'm not sure there's this much, and there certainly wasn't a federalism majority in the Trinity Lutheran case.
Well, federalism is different from playing the joints, right? I mean, federalism would mean a state can set a different standard from the U.S. I understood Adam's question to be that.
I mean, I'm just wondering whether you can think of the federalism argument in a different way. I don't know how this sounds to you, but remember, state law is doing all the work up until you get to the First Amendment question in this case. So the program is enacted under state law and invalidated under state law.
Right.
And it's almost like it was never, the state just never enacted the program in the first place. And so from a federalism perspective, is that a way to think about this? Like a state would have a right just not to have a program like this? That's really, at the end of the day, the only decision the state of Montana has made.
But it's not, again, it's not state federal, but I think that's right, that one weirdness, one oddity about the case is how is this different from if Montana had simply never established a program? And supposing there were even a record in the legislature of saying, you know, let's not establish this program, because if we establish this program, you know, there'll be an issue about funding religious schools too.
Yeah.
So let's not even start down that road. Now, does that, at that point,
Right.
sort of raise these
Yeah, that's what
questions?
I don't know if that's something.
Yeah, I mean, that's sort of a different issue. To me, the playing the joints and federalism are directly related in a different way, which is just, if there's playing the joints between the federal free exercise clause and the federal establishment clause, then if there is playing the joints, then the states get to make the decisions as to where they want to be in the playing the
Well,
joints.
but-
What I think is turning out in this doctrine is there's a lot less playing the joints than maybe you thought the first time Chief Justice Rehnquist or whoever used that phrase. And so there is kind of less of a room for states to choose. I don't think anybody's going to argue at the end of the day that a state has to have this kind of program. It's, you know, so to deal with that issue, you may have to get into more of this. Well, yeah, you could have chose not to have it at all, but since you chose to have it, and then you ended up kind of getting rid of it only because of.
It's a lot like the
belief.
guns case. They used to have it, they choose not to have it, but the court decided anyway.
I think it's a little different, but,
But it would be an interesting question if the state had simply repealed it
Yeah.
at
Yeah.
some point, yeah.
yeah, you know, but it might depend on why they repealed it.
Well, would it? I mean, that.
Well, no, I think if you got, if, you know, if the legislature went in there and say, we're repealing this because we can't figure out a way to have this assistance for schools without it going to some Catholics. I mean,
Well, if this-
and
right.
therefore we're going to repeal this pre-existing policy?
But there's a lot of, I mean, if it's true, if the state announces that, but there's a lot of talk in the opinions about how we don't like to look into legislative motivation. It's very difficult to get at. There's so many members. So it would be odd for them to end up in a place where they have to do that.
Let's see if we have just one or two questions, and then we'll have to close out. Yeah, back.
If the New York Rifle and Pistol Association case doesn't ultimately go before the Supreme Court, do you anticipate them taking on another case that they can use to address Second Amendment issues, like how we anticipate that they'll take on some abortion cases to look at those issues, or is it more likely that it's this case or no case for now?
I think they're ready to play.
Feel free to say no, I don't know.
I mean, I think it depends on why they took this case. They didn't have to take this case. They had cases out there that presented broader questions. And so if the reason that they took this case is it provides a nice opportunity to sort of, you know, put a toe back in the Second Amendment waters after taking a decade off, then there isn't a particularly close substitute for this case. You know, I think if the court's, you know, raring to go to take, you know, one of the broader carry issues, then of course they can do that. But it's not super obvious to me if that's what they were really interested in doing, why they would have granted the New York case first instead of just, you know, holding it and taking one of the broader cases.
It is true that the New York case is wonderfully trivial. It's a silly little law, it's been repealed. And I do think the court may be afraid of announcing a broad Second Amendment ruling on some Tuesday morning and then having a school shooting that afternoon. That would be a bad look.
Other questions? Okay, let's thank the panelists then. Thank you.